The development of technology companies, of SaaS companies, of fintech companies, their assets, their valuable assets to the world, to an IPO, to an eventual sale, is going to be their intellectual property. And understanding that their IP stack is its most valuable asset, its brand connected to that IP and assets are its most valuable asset is key.
Welcome to SaaS That App, building B2B web applications, the podcast where we share real-world stories, practical advice, and tech insights for those building or thinking about starting a tech-enabled business. I am your co-host, Aaron Marchbanks.
And I'm Justin Edwards. Each week we bring you the stories, strategies, and insights you need to build your SaaS or tech-enabled business smarter, not harder. Let's dive right in.
Hello and welcome back to SaaS That App. With me, as almost always, my partner in crime and good friend over here, Justin Edwards. How are you doing, my friend?
Hey man, it's been a busy week today.
Yes.
And it's only noon.
And it's only noon halfway through the week. I would say downhill slide, but we're not quite there yet. And it never seems to feel like a slide. It just feels like continued uphill climb to Friday.
George Carlin fans may be familiar with SHIOW. And yeah, it's one of those.
Fair enough.
HSIOW.
Oh, man. Love me some Carlin. Well, joining us also today is Gabriel Saade, a partner at DarrowEverett LLP and chair of the firm's intellectual property and technology practice. Gabriel works with companies across the country, especially startups and growing businesses, helping them to protect their intellectual property, structure deals, navigate mergers and acquisitions, and avoid just all kinds of legal pitfalls that can derail a company as it's scaling. He also serves as outside general counsel to more than 100 businesses, advising founders and leadership teams on legal strategy and how to build durable companies, all of which we're going to get into today. Gabriel, welcome to the pod.
Thank you. Good afternoon. Thank you for having me.
Absolutely. So first question, always the hardest one, and just to kind of set the stage in context. So you started your career on the litigation side. You're spending a lot of time now advising businesses strategically. So what drew you into law in the first place, and then specifically toward technology and IP?
I like to be honest about really what it was. It's not really a grand story. The truth is, and in short, I was a failed baseball player who found himself with a Duke degree, 2 injuries that weren't going to allow me to pursue my career as a baseball player. And I was interested in businesses. I had already opened and sold an import-export company as a senior in high school. It was an import-export company of shoes called Counsel. And we bought from them. We had an exclusivity deal. And then I showed up at Duke University as a starting shortstop and realized there is no way I am going to pass, be a decent baseball player, and run a business. So we sold it. But when I ended my career after a couple of injuries and realizing that I needed to find a new path forward, I had 4 years of baseball in college, in summer ball. Instead of working, I was in the summer leagues. I was in the Cape Cod League, trying to get scouted and make it as a professional baseball player at some point. And every single business application or MBA program that was available during that time wouldn't take me because I had no business experience. So my wife was at that time a 1L. She had her first year of law school and she was like, why don't you just go to law? You can get in. You don't need any years of working experience. So do it. So I did it. I sat for the LSAT. I got into FIU Law School where I started law school career. And then I graduated from the University of Miami. And the reality is I found law school great. It was very competitive, especially the first year. You're really sizing up your competition. It was a battle. And for me, being a collegiate athlete, a really good one, and being at Duke, my days were already 16, 18-hour days between practice, workouts, post-workouts, and class, right? Trying to compete with one of the smartest people in the country. Every class, I felt like I was the dumbest person in there. And having that level of hard work and dedication when it came to just being a law school student, it was very easy. So that's how I got into law. To be honest, it was per happenstance. It was also 2 years or a year removed from our depression, from my generation, right? So the '08 and everything that happened there. So it was hard to get into any real good job because everyone from the years before me were waiting for those jobs to open up again because there weren't any. Same thing with master's programs or MBA programs. They were so full. So our options were limited, and I made a decision that somewhat interested me. Both my parents were attorneys in Venezuela, which is where I was born and where they worked as attorneys. So it was somewhat in the background. And after my first L year, really after the first semester, being in that environment, competing, learning a new language, learning how to read and write and speak differently, which is what really the first L year is all about, is knowing the lingo, understanding the language and being able to articulate it well when someone asks you questions about it. I think that's really what it comes down to. And I fell in love with it. And I fell in love with the interconnectivity between, real life businesses and how intermingled it really all is, and how every single day, even our most basic relationships are all contracts, whether we realize it or not. Right. And so that's where it started. Not really a good way as to why I chose the law, but I just kind of stumbled into it and then fell in love with it. And the rest is history, as they say.
No, I like it. And Justin, unless I'm misremembering, in an alternate timeline or a multiverse situation, you also were heading the lawyerly route.
Yeah, kind of like Gabriel went to law school, was like, well, whatever, it's easy just to get into law school, apparently. Yeah, I failed going to law school because I got a computer science degree. But yeah, definitely interested in the law. I was actually headed a similar direction to, it seems like, where Gabriel went, whereas I was interested in IP law and corporate law and working with small companies and new companies. So yeah, definitely an interview I'm excited for, because it's the path that I never got to walk, but I was on for a while before I found out that someone would write me a paycheck with a computer science degree. And that was the end of my academic interests. So
it's amazing how that works out. So Gabriel, back to you. You found your own law firm, but before you joined a larger one. And so as we're kind of leading into where we're going to be taking the interview, we have obviously a lot of listeners that are very interested in business and entrepreneurship and things along those lines. So what lessons did you take away, or what did you learn from running or having your own practice that taught you or maybe guided you into the situation you're in now, where you're part of a larger firm?
I mean, there were so many lessons, it's going to be hard to include them all.
Give me like a top 2 or something.
I think the most important thing I realized very early on was that my Duke degree, whatever accolades I received during law school, none of that really mattered when it came to opening up a law firm, getting clients, more importantly, keeping them happy and sustaining them throughout the growth of the law firm. It was really about relationships. It was the social capital that I had accumulated up to that point, both professionally as a former litigator working at a larger firm before I started my own law firm, as well as personal relationships and, different clubs that I was involved in. At that point, I was very big into triathlons, and I was doing a lot of long distance triathlons. And you'd be surprised, a group of a bunch of skinny dudes riding in tights all around Miami, you build a lot of good relationships, and you have 2 or 3 hours of really getting to know people and understanding their businesses and what they do. And all of those key relationships was really the foundation of Saade Law. It was what got us basically all of our clients. I would say in the 6 years that I ran my law firm, over 95% of our clients came from my social capital. It came from people that I knew, people that I worked with, people that I was friendly with, that I trained with. I can't emphasize enough how important it is to have conversations when you're anywhere. Just meet people, be nice, be courteous, tell them about yourself, but more importantly, ask them about them and what they do and what they love, and provide context and value to their life, because that's going to pay dividends down the road. And I'm not saying just do it for that reason, but if you do it, it does pay dividends, and it is really the foundation of the firm. I would say all the marketing and Googles and ads and videos, 5% or less of our clients came from that. And then the second lesson, and I think the harder one to learn, happened very early. So I started the law firm April of 2019. We all know what happened March 2020. So I really needed to be conservative in how I grew and the pace of the capital that I was spending, the rate that I was spending. It's very easy once you're in it to kind of continue to grow, and you have so much work that you feel like you're drowning, and all of a sudden, you go from a firm of 2 to a firm of 5 to a firm of 10, and it starts feeling like it needs to grow at that pace because the work is there. But COVID really was like, hey, buddy, everything's done for 3 months or 4 months or 6 months. How are you going to continue to grow? How are you going to pay your payroll now? Clients aren't going to pay if you're not working. Clients aren't going to pay for litigation if there's no courts. And that lesson of being conservative, being patient, taking your time, knowing that everything comes in bell curves, really, because, you're really busy. You feel like you're suffocating. You're concerned as a lawyer that deadlines are going to be missed, are going to be blown, and you need the staff to make sure that that doesn't happen. But then there's a lull in the work because there's a natural flow to litigation. There's a natural flow to workflow. And only once you reach a certain volume does it stop being a bell curve and more of just like a straight line across where you have just steady streams of work. So when one company doesn't need you, the next one needs you. And that one doesn't need you, the next one needs you. But it takes time to build. One of the mistakes that I made was growing too fast. We started doing very well very quickly and grew. And one outside general counsel job turned into 100 in less than 2 years. And so, having the patience to grow slowly, methodically, be ready for a COVID to hit, even though, God willing, it doesn't ever happen again. And we all lived through it. I think we all learned a lot of different lessons during that period, but being ready to sustain and asking yourself as the owner, the hard question, if you didn't receive $1 for the next 3 months, would you be okay? Would your employees be okay? Would your family be okay? And if the answer is no, then you really got to take a hard look at what you're doing, how much you're spending, where you're spending it, why, how much time you're spending on what, and have those tough conversations with yourself very early on, because those will pay dividends later on.
Real quick, this episode is brought to you by Delta Systems, which is what Aaron and I do when we're not talking through microphones to you, the people of the internet. We've got a really, really great software team here, and we love to work with cool people on cool projects. So if that sounds like you and you've got a problem or you're in some kind of a jam, go to deltasystems.com, grab a time with us. We can beat up on your problem together, and if there's a fit there, amazing, we'll help you out. So deltasystems.com, grab an appointment, and hey, maybe we can work together.
I love the notion of it's who you know, even more so than what you know. And that's something that my wife and her family talk about all the time in business as well. It's something that I heard growing up, and I consider myself kind of a people person. And so that really rings true for me because I don't know very much, but I know a lot of people. So that's always been something that you can lean on, those relationships. That's great.
Yeah, I can't echo that enough. We had the exact same experience, and still to this day, sometimes my phone rings and a lot of money shows up because someone knows my name and knows who I am, even though I haven't been putting myself out there in that way for a long time. It's your network and your brand and people you know. So I love that you highlight that. What does outside general counsel do? And then how does more generic corporate law and IP law kind of differ? And what was your path through those different things?
Yeah, and it all started with what I alluded to, which is when COVID hit. And I was a serial litigator at that point. I had done some corporate contract work, started really as a litigating attorney for contract disputes, partnership disputes at the end of my career at my first firm. And when COVID hit, courts were closed. The only work that I had coming in was this outside general counsel concept, which is simply, in that day, it was for a multifamily developer that just needed help with their joint venture agreements for the development of multifamily developments that ultimately they hired themselves to develop, to construct, and then transferred it to their own property management. And that property management entity ran the multifamily for several years. And so when the JV needed help in terms of contracts, so just very basic third-party contracts, when they were going through vendors, negotiating with AT&T to install all of the service lines and everything within the development so that every single unit had, it's Cat 5s, it's Cat 6s, and it's internet, it's telephone lines. They themselves grew very quickly as well, and their in-house counsel really couldn't keep up with the volume. So they reached out to me, say, hey, I know you litigated some of this stuff for us. Can you just negotiate the contracts for us? And so I came in as, at first, just negotiating. I was very good at talking, and I can talk someone until they didn't want to see me anymore or hear from me anymore about one single provision of a contract. And they're like, whatever the guy wants, just give it to him. Just get him off the phone. And really that led to doing more of that work. And so instead of just negotiating those contracts, I was also drafting them. I was redlining them. I was revising them. And I was the overflow for in-house counsel. So that's the way I like looking at it, is outside general counsel is really the overflow of everything that an in-house attorney does whether it's corporate structures and corporate documents for relationships between the partners themselves inside of a business entity, to relationships with outside parties and third parties in their vendor contracts. And that's how it all started. And that kind of practice grew from my client 3, 4, and 5 to my clients 5 to 85, all came as outside general counsel. And it was a service that I realized, especially during COVID, was essential because there were many things that I had experienced in that most in-house counsels had never. Most of them have never litigated these type of provisions. A big thing that was happening then was business interruption insurance. No one had business interruption insurance. No one really looked at their insurance policies as a business owner to determine, well, this isn't a force majeure necessarily. This is COVID. This is not defined. This is something that has stopped all businesses, and my insurance company should be prepared to cover my losses. And that wasn't the case. And so it was about providing some of those litigation standpoint perspective to contracts that were existing that in-house counsels weren't prepared to handle, and expanding from there and allowing them to use me as a resource to supplement their work. And that's how the practice really began. And that's how, Saade Law grew in the first couple of years, was all providing this very unique outside general counsel perspective and assistance to all of the in-house counsels that were essentially my clients. They were the people that I was reporting to that would give me my assignments. And sometimes they took credit for my work, but that was okay. So long as the business thrived and excelled, and those contracts ended up being very profitable and useful for them.
Yeah, it sounds like very similar to doing tech consulting. Just obviously it's legal side, but we do fractional CTO, and sometimes our work gets claimed by other folks internally, and that's kind of fine. And we get a check at the end of the day, which is why we show up. So I know how that goes.
I actually, and I don't know at what point in the conversation we talk about it, but I had a very interesting call yesterday about something like this, right? Essentially hiring a third party to do work that from an outsider or a consumer standpoint appears to be the work of the entity, but it's really this third party that's handling it, and the legal consequences of that and the reality of that once litigation ensued. So it's pertaining to ADA compliance. I don't know where in the podcast, and I'm not trying to dictate where we go, but that's something that's currently being litigated in New York right now, and you guys probably can speak intelligently about it.
Yeah, tell me more about the scenario. What was the issue?
So I don't know if I'm allowed to say names, but I won't say names. But there is a company, software company, that you hire to review your website for ADA compliance. And they do that. And they go and they run audits of the websites. They make sure that all of the functionality of the website is working properly, that anyone, whether disabled or not, can fully access every aspect of that website, whether it's ordering, whether it's finding a location, whether it's contacting someone, it is accessible. And the reality is that they make those changes to the outside world and it appears like it's fully functional. But the moment you stop paying their monthly services, those changes, those compliance changes that were made go with that subscription. They actually don't do the changes on your website. They have an overlay over your website that from the outside world appears that, hey, this is compliant. This is all working. This is fully functional. It is accessible. You stop paying your monthly fee, your website goes back to what it was before you ever hired these people. So all the work that you've been paying for, all of the accessibility that you thought your website now had and that was in full compliance is not compliant because you stopped paying that monthly fee.
I can imagine that it's like a really useful thing for some business where like they have this complicated website. Maybe they paid someone to build it. They don't really have technical people on staff. They don't really know how to manage it anymore. And now I come by with a monthly subscription offering where I can take that thing and without having to get into the guts of this mess, I can make it ADA compliant and get them what they need. If that's a monthly fee, it's a weird business model, but I could understand it being a benefit to somebody. If I'm also paying them hourly to make the changes and then they take that stuff away.
Why aren't they making the changes to the actual website? Why are they just doing it on an overlay that is essentially work product that they keep and they take with them? And that you're essentially married. I wouldn't even say married because to me, marriage is a good thing, right? So you are bound in handcuffs with this company essentially for the rest of the life of your business. And if the regulation changes, nothing's adaptable unless you pay. And if that company gets sued because those changes were never actually made and is not accessible, that liability falls squarely on who? The people that you hired and guaranteed your website was going to be accessible? Or is it the business itself who, didn't have the technical expertise to understand that the changes that were being made to your website weren't actually being implemented? They were just a fancy little overlay to the outside world that made it accessible, but only if that add-on, only if that plugin was at the bottom of your website and you were paying that monthly subscription. And if they wanted to increase your subscription or double it or triple it, you had to do it. And if you didn't do it, guess what? Now you're not accessible anymore. And the 10,000 plaintiffs lawyers that are out there basically attacking all business owners, not just your large business owners, small mom and pop shops, small landlords, they're all getting attacked for the same exact thing. Your website isn't compliant. It's not accessible. And that plugin that you're no longer paying for because you thought, you know what, you guys already made all the changes. Why do I have to keep doing this? Which makes sense as a business, right? Why are you going to keep that on your balance sheet? In fact, was never made, and they took it with them.
I just don't understand why I would pay someone a subscription fee and then also pay them an hourly fee to make changes. Like, if I'm paying them to write code, I realize it's contracts, but I should own the work product for that. And if I'm paying them for a service and they're doing this overlay to earn my subscription revenue, that makes sense too. I'm not going to talk about liability or legal stuff with the lawyer on the phone. Normally I'll opine about that stuff, but not when I have an actual lawyer on the call. But the business model seems morally dubious to me. Like it seems like it's kind of designed to be kind of an ugly entrapment style business. And that kind of gives me the creeps a little bit.
Yeah. And that's why they're being sued in the Southern District of New York right now. But the problem is, in the meantime, there are hundreds of thousands of companies, all of which relied on the representations of this company to make their websites accessible that are now subject to lawsuits. And you know what the reality is? I defend a lot of these companies. It's part of what we do. It's money in my pocket every time someone gets sued for ADA compliant, whether it's website related or brick and mortar. And I do it to my own detriment in a way that I feel like it's fundamentally unfair. And if you're paying for a service, you need to be very diligent about what it is that you're getting, whether or not you own that work product. And that's something that you can keep and take with you. And what are the consequences if there's a failure? Or in this case, your website isn't accessible. Who bears the responsibility of doing it? Do you have the right indemnity provisions in your agreement? Do you have the ability to be held harmless if in fact you get sued for this exact thing that you were paying to prevent? I wrote an article about, ADA lawsuits and how pervasive they are and how destructive they really are. And it's really a problem for the legislator. And we're not going to solve it on this podcast, but it is very frustrating and it becomes super, super important. And that's just another example of why sometimes your pure in-house general counsel, a guy that has never stepped foot in a courthouse, has never had to litigate the contracts that they're assisting their companies in executing, doesn't have the necessary perspective to realize this isn't enforceable, this isn't fully transparent, and I'm not really getting the coverage and the indemnifications that I need to really protect my client and my business from future liability. It's a sad reality, and it's one of those things that when COVID hit, we realized very soon that this is something that we can really provide a different perspective, and this outside general counsel concept really created.
We also have clients who deal with these kind of ADA trolls, I'll call them, and they're just mass marketing these nasty grams to people saying that we looked at your website and it's not ADA compliant, and for $5,000 we'll go away, otherwise we're going to file a lawsuit.
So those trolls have gone away, a lot of them, because enough people have called their bluff, but now they're actually filing these suits. I was just talking about New York. I'm licensed in New York as well as Florida and 10 other states. But New York, the Southern District of New York just got over 2,500 website ADA cases filed in 3 months. So they've turned those letters into actual lawsuits in federal court, which is very scary for a lot of business owners. It's nerve-wracking for general counsels and those who don't do this kind of work. And you have to act quickly. You have 20 days. If you don't have an outside litigation counsel to retain counsel, hopefully find someone competent enough that has done this, that has an expert that can go and provide you with a certificate of conformity and say, no, you're wrong. We were actually fully compliant. And here's why. And it is a process. And it is something that unfortunately companies really need to take into consideration soon.
So where is the line where this crosses into, like, I forget the correct term, but like you're litigating to be a menace? It's just like nuisance litigation. How does that get sorted out?
It doesn't. It doesn't. And the reality is federal courts don't want these cases on their docket. They're going to push you to settle. I had a court in the Southern District of Florida on its own, sua sponte, on its own accord, submit an order saying, you guys, I'm going to close the case out. You have 30 days to settle. Send me your settlement at the end of the 30 days. If you don't settle, I want you to tell me why. So they themselves already closed the case conceptually, really prohibiting us from really providing a defense, and instructed us to settle the case.
That's like the legal equivalent of talk to the hand, right?
Talk to the hand or to your local congressman and go see if they will change the law, because the law gives plaintiffs' counsel and these individuals the civil cause of action. Whether they get damages or not damages, you end up spending more time and more money fighting it than you do resolving it. But it's gotten to the point where it's abusive and it's really burden, especially on small business owners, on landlords that own one property that are barely making ends meet. And now you throw in a $5,000 or $10,000 settlement, having to hire an expert. It could really disrupt, and if not bankrupt, businesses.
I got one more legal thing, Aaron, and I'll stop talking over you. So do you think there will be, or would you support some kind of like a SLAPP lawsuit equivalent for these kinds of cases as well? And you might be better to define SLAPP than I am, but yeah.
I 100% would support it. Not only would I support it, I have reached out to a lot of my colleagues and friends and lobbyists to say, I need you guys to help me put together some kind of SPAC and some kind of organization that can go out and reach out to companies and get everyone together to make some change, because this needs to change. It cannot be this. It should not be up to plaintiffs' lawyers across the country to enforce federal statutes and state statutes regarding ADA compliance. It shouldn't. It's disrupting a very important part of our economy. It's destroying small businesses, and it is creating an incentive for people not to open up and to be entrepreneurs. And not even entrepreneurs. A lot of times, I grew up with I want to make enough money so I can go buy a property and I can rent it out and I can have that rental income and I can supplement my income. That was a big dream of many people. But now you open up a shop or you get a house and you lease it out, you run the risk of all of a sudden I get a lawsuit from a plaintiff's counsel and it's going to eradicate all my winnings for the entire year. Or, you bought something that was pre-2010. You were compliant pre-2010 when the ADA changes were made, and there's been other updates since then. And you didn't do anything to the building other than buying it. But to prove that you didn't actually have to become ADA compliant in accordance with the 2010 regulations, it's going to cost you more than giving plaintiff's counsel and their alleged handicapped person $10,000 to resolve the case. It's very unfortunate. It's something that needs to be changed. It's something that we need to gather all business leaders and business owners and say, enough's enough. Let's go to Tallahassee in Florida. Let's go to, your congressman. Let's go to DC and let's make changes, because this is not the path forward.
And so this is not about not being accessible. This is about people, plaintiffs' attorneys, using the legal system to extort money, using bad laws and a bad legal system to extort money out of small business owners who, when there's not an actual damage or there's not an actual grievance. We're not anti-accessibility. That's absurd. But this system is what's being done right now, kind of in the name of the system, is bad. And there's got to be a better way for us as small business owners to be more accessible and to do a better job, but also not face this kind of bullying and extortion, which is, in my mind, what it plays out to. Really quick, because I want to close the loop on SLAPPs. So there are laws in a lot of states where if you file a lawsuit against somebody and it's mainly you basically assert that basically the only reason you filed this lawsuit was to cause somebody problems and stop them from expressing their opinion in public, then there's a mechanism that short circuits the whole lawsuit. And so we're talking about installing something like that, where it's if we could assert that these ADA lawsuits are in some way like a nuisance or like an extortion style lawsuit, then it puts a burden back on the plaintiff to actually say, no, I've got a real case, and then they have to come back and present more. Is that a fair treatment, Gabriel?
Absolutely. And you know what? I would say, and most people that I've dealt with, that I've represented, and it's thousands at this point, unfortunately, they will all say the same thing. That individual who's filed this lawsuit has never stepped foot in my store. They've never come to my building. They didn't even try and access. The kind of person that allegedly the one bringing this lawsuit would never visit my website, because we don't sell to that demographic. In fact, you would never go there. It's just not something, it's a man in a online store with women dresses only. You know what I mean? That's just an example. It's not based on any truth, but that's just the kind of thing that you see, and something needs to be done to stop it. I feel like I took you guys in a path that was completely different, but it just triggered that thought in my head about, these outside parties and how important it really is as counsel for you to be aware of the potential consequences of not understanding fully how important and how these SaaS companies, right? And these cloud-based companies that perform work that you rely on your day-to-day, you don't own your data. You don't have your information. There are confidentiality risks in it. And you need to be fully aware of how you're using them and what services are actually providing you and what protections you have in the event things go wrong.
Yeah, absolutely. And over the years, and many years now that I've been in this business and actually at this current business, we have helped people who have had to bring that to us and ask, hey, we got this thing. What does it even mean we're not compliant? And have to help them sort it out. And we always have to preface by saying, well, we are not legal counsel, but here is what we could do to help should you actually find you need it. And then it becomes an extra hassle for them because not only are they dealing with the litigation aspects and all the costs and time associated with that, but now they're also having to deal with us because, frankly, we don't work for free. So it's trying to find a balance to help them, a long-term client, balance against this thing that's just so frustrating. And that is a prime example with the ADA, but it's been with other things as well over the years. When you start talking about systems and software and applications and e-commerce processes, having the right steps, going through the right steps. Do you do it this way? Well, why would we? There's just silliness. I don't know how else to put it in. I know that that's not legal terminology, but silliness, I say. So I want to step back a little bit, and this is going into my next question pretty well, but taking the focus off of ADA specifically, and also now generalizing this to technology and software companies in a broader sense, what kinds of legal mistakes or legal footings do you find that founders and CEOs and entrepreneurs make really early on that become very expensive later?
Yeah, I think, one of the things that is essential, and it depends on the type of business you're in, it applies primarily to companies whose assets are not fixed, right? If your assets are fixed, then it's not necessarily as important. But the development of technology companies, of SaaS companies, of fintech companies, their assets, their valuable assets to the world, to an IPO, to an eventual sale, is going to be their intellectual property. And understanding that their IP stack is its most valuable asset, its brand connected to that IP and assets are its most valuable asset is key. A lot of times I have come across very great, and let's just stick with software companies, fintech companies that have great products, that have great services, but failed to, at the very beginning, dive into the market to evaluate whether or not they can brand themselves. Because, you can always update your codes, you can update your software, you can improve it, you can change it. But what you can't always do is change or modify or adapt your brand, because brand recognition, goodwill associated with your brand, and that brand recognition and the quality of service that you're providing is key. And that's, at times, that goodwill is one of the more valuable things that you can trade. And if you don't take care of that at the very beginning, you may find yourself with a great product and an opportunity to grow, an opportunity to expand, an opportunity to sell, but you can't, because there's 5 other companies with your same name, same kind of sounding name, your same kind of mark, same kind of logo, that could create extreme confusion, that can make you lose market share. And that ultimately may cost your ability to grow and expand and actually sell the business because you can't protect it. So going through that diligence at the very beginning is very, very important. Is my name out there? Is it already associated with a particular service? What is that service? What class are they in? And what can I do to differentiate it now, when I'm still mobile, when I'm still agile, not when I've invested $5 million into the business and you've created a great reputation for yourself within your geography. But the moment you get out of Miami-Dade County, if you're in Miami-Dade or wherever you are, there's another competing business that offers a similar service that sounds just like your company, you just did a disservice to yourself, to those who were invested in you, and to the growth of your business. And, we all live and have dreams to grow and to expand, but you got to take a step back, make the right investments at the very beginning to explore the viability of your brand.
I'll refer listeners back to a super early episode we did with Reed Lyle, who owns a print shop in the Midwest. And the original name stepped on the toes of Yeti, the cooler maker, even though it was not the same name and they were not in the same business. And Yeti's a national brand and he had a local brand and on and on. And well, he doesn't have Yeti in his name anymore, even though these businesses had nothing to do with each other and the mark was very different. It wasn't worth the fight, basically. So he changed his name and got pushed around by them. I think that's exactly what Gabriel's talking about, is do your research early on.
Yeah. And the reality is we fall in love with names. We fall in love with a logo. We fall in love with it as owners. And then ego takes over and you want to do everything you can to protect it. And this is mine. But the reality is the law doesn't care really what your ego says or what you love, but what's going to prevent market confusion. And that's really the job of the USPTO at the federal level and other trademark and patent offices is we need to protect the integrity of the names and brands that have worked very hard to provide a good and service and be associated with it. And you can't just come in because you love your name and demand a presence in the market.
Yeah, absolutely. I've got several more questions along the lines of like licensing agreements and, things that might complicate intellectual property in general, but I'm also kind of keeping an eye on time. So I want to shift just a little bit. So, it's a little further down the line now in terms of business maturity. You've handled some more complex business disputes, partnership conflicts, shareholder disputes. I'm curious if there are patterns that you can share with our listeners that you see and how companies end up in those situations. Branding and brand awareness, marketing aside, what can business owners and entrepreneurs and founders do to avoid those types of patterns?
Yeah, I think you touched on it, and it's having the right licensing, the right agreement in place, even intra companies. A lot of things that occur over time is the owner himself is the registered owner of a mark. The company is now a multi-million-dollar company. It goes to an IPO or it goes for an asset purchase or some kind of sale, or it's trying to get funding and it's trying to do a big cap raise. And people are saying, okay, what does the company own? What are its assets? And they never realized that the intellectual property, that the trade name, the trademark is not even owned by the company that's asking for a $10 billion valuation. It's owned by one of the owners. He has it himself. Or there's a business dispute between the members or between the shareholders. And one owner's like, okay, we can argue, we can fight. I own the mark and the brand and the goodwill is going to go with me. And it's not an asset of the business. So it disrupts the negotiation table. It creates havoc. It stops sales from occurring because your most valuable asset isn't owned by you. And you never looked at it or determined the reality of it. And they just think, well, I'm the owner. I'm the guy. I'm like, yeah, but it's the business that you're trying to ask other investors to invest in. And you don't own your own IP, or the company that's raising the money doesn't own its own IP. I think that's a very common mistake and it happens. You'd be surprised if I gave you the names, you'd be like, there's no way that company did that. And that's the reality of it, is that those corporate documents, those internal agreements, those internal licensing agreements, a subsidiary has grown and it's outpacing its parent company. And the parent company has been the one that really pushed this up to grow and funded it. But they never had a licensing agreement between them. And the parent company wants to use that, continue to use that mark. And now the sub has grown big enough to say, no, this is our brand. You don't have any rights over the brand. Thank you for your capital investments. You'll get your returns as a member or shareholder if you structured it that way. But we're going to grow and we're going to independent and we own our own IP and you don't even have a license to use our IP. It happens a lot. So take care of your internal documents as much as you want to protect against third parties and you want to have those licensing agreements. You also want to make sure that those internal contracts are in place.
That was actually going to be kind of my next question is, what can people do to prevent that, to mitigate that sort of an issue? And, is it something just as simple as making sure it's under the name of the business and not the person? And then how does that wrap around larger intellectual property like code bases, like the actual software itself outside of like the marks and the branding?
It's all contract based, and it's all got to be put into a structure that makes sense for those who are paying for that code, for that software to be created, to be developed, and having those agreements in place to ensure that any and all work product that is created is retained by the person who is investing for it to create. So I hire Justin and Aaron to develop some really fancy technology and take my business to the next level. Whenever you're done, I own what you did. And if I don't have that very clear, if my contracts aren't very explicit about that, you guys can take it and run. And now what am I going to do to protect myself?
For any current or future clients, we have a very clear assignment clause in our contract where you own all the IP that we write for you as soon as you pay us.
Thank you, Justin.
I wanted to mention that.
Yep. Let's make sure that is out there.
Yeah. As soon as you make that last payment, it becomes and automatically, without any need for anything else to trigger any other provision, it gets assigned to the owner, to the true owner, not the developer, right? But you'd be surprised how many agreements don't have that very clear.
No, it's incredibly important, especially because the default is the person who did the writing owns the rights, unless it's assigned, I believe.
Right. It's your creative work.
So we actually had a customer recently that was uncomfortable with even the we own it until the payment. And we're like, well, we can solve that really easily. We just advance the payment. And that they're like, that's great. So we get paid before we even do the work, just so that there's at no point ownership to us. And that was totally fine. We changed our contract and no big deal. So yeah, super important.
Yeah. And the next level of what we're talking about is what's going on with AI, right? So I hire you to make some type of software development. You use AI in part to provide me with the work product. The AI was the one that in part created the work product that I am now receiving. Who owns the work product? Did you actually do the work? Is your contract fulfilled because you in part provided services through the use of some generative AI tool rather than your own skills, your own abilities? And how do we differentiate between that? How do I negotiate a reduction in what I'm paying you? Because ultimately half of your job was done by something else. And then in using that generative AI, did you supplement or teach or train that generative AI based on confidential information that I provided you, of which we have a NDA or some kind of confidentiality agreement with, but that doesn't apply to whatever platform you used? If you put that information into ChatGPT and it spits something out and you use part of that, well, what contract did I have with them or did you have with them? And how did you protect mine? Did you breach it by using this generative AI? So some of these concepts also have to be included in licensing agreements. They have to be included in marketing agreements, development agreements, software licensing. All of those next level of intellectual property and AI concepts need to be evolved, adapted, and protected in your day-to-day operations, because every single day we become more and more intertwined with generative AI and all these tools that we're all using on a daily basis.
Yeah, and I so much want to get into this with you too. I mean, I have we're going to have you back, man, because I really want to get into the legal aspects of AI.
And the privacy aspects. And there's got to be tons of cases of first impression happening on everything you just mentioned right now. We don't know what the landscape is. It's crazy.
It is insane. I'm the chair, as you mentioned earlier, of the intellectual property and technology department of our firm. And I would say more than 85% of our time comes in providing opinions related to AI and its use in the legal world. I mean, it is incredible. And for us, so at DarrowEverett, we have very strict policies on what you can use. And we have now started using Harvey AI. I don't know how familiar you guys are with Harvey. And it is a generative AI tool that you train and you provide data. And the confidentiality protections are extremely tight. We consistently evaluate them. And it is the most important part of any of it, because we could be committing malpractice. We could be violating attorney-client privilege every single day using any of the tools that are seemingly accessible by putting things to Copilot, asking Copilot a question that the Copilot should never hear about because it's attorney-client privilege. How do you protect against that? How do you ensure that that's not happening? And yeah, I can spend another 5 hours on just this topic alone, but it is very interesting.
We'll have you back for at least one more. I would love to go super deep on AI, security, privacy, disclosures, NDAs, all that stuff is fantastic. We're kind of running into the end of our time here. Is there anything we should have asked you, or where can people connect with you?
You can reach out to our website. All our information and contact is there. My email, gsaade@DarrowEverett.com. Happy to help or provide any context or explanations or anything you heard here today. I hope I didn't scare everyone into starting their own businesses. That's not my goal. But you do have things to consider, and we have to all realize the world that we're living in and how uniquely prepared you need to be to start a business and to thrive.
That's fantastic. It's been a great new angle of discussion for us and one we've been very anxious to dive into. So thank you for sharing your time and your insights and talents with us today. We've been talking to Gabriel Saade, partner at DarrowEverett LLP and chair of the firm's intellectual property and technology practice. Reach out to him if you've got questions about any of it. Also, a special thanks as always to our listeners. If you like what you're hearing, have ideas for the show, or just want to tell us what's on your mind, hit that like button, throw a review our way, subscribe if you are so inclined, and we will see you all next time on SaaS That App. Thanks for cruising along with us on SaaS That App. We hope you grabbed some insights that were inspiring, actionable, or at least entertaining.
If you enjoyed the show, don't forget to subscribe and leave a review.
Until next time, keep building, keep growing, and keep those apps sassy.